evening, everyone. It's my pleasure to welcome you to the Bangkok Court for the third Selden Society lecture for 2025 on the origins of contemporary judicial power in Papua New Guinea. We are deeply honoured to be joined by the Chief Justice of Papua New Guinea, the Honourable Sir Gibbs Salika, as the commentator for tonight's lecture, together with Lady Salika. I acknowledge all the other distinguished guests who are here, members of the profession and members of the public, and thank you for your support of this important lecture series. As a mark of respect, I also acknowledge the first owners and custodians of the land and waters across Queensland, here in Brisbane, the Turrbal people and the Yuggera people. I commend their ancestors and elders for their wisdom, courage, resilience and leadership. I'll begin by introducing our speaker for tonight, and I'm delighted to introduce the Honourable Justice John Logan, RFD, Judge of the Federal Court of Australia. His Honour was appointed to the Federal Court just over 18 years ago, in September 2007. His Honour holds degrees in Economics and Law from the University of Queensland. Justice Logan was admitted to the Queensland Bar in 1980, and at that time was working in the Commonwealth Crown Solicitor's Office in Brisbane. He commenced private practice at the Queensland Bar in 1984 and was appointed Senior Counsel in 1999. Justice Logan was commissioned into the Australian Intelligence Corps in the Army Reserve in 1976 and held the rank of Major in that corps before transferring to the Standby Reserve. He was awarded the Reserve Force Decoration in 1993 in respect of his military service. Reflecting that aspect of his career and interest, His Honour has served on the Defence Force Appeal Tribunal since 2011 and been that tribunal's, I think it's the Defence Force Discipline Appeal Tribunal, and been that tribunal's president since 2018. He also held an appointment as a Deputy President of what was then the Administrative Appeals Tribunal from 2010 to 2020. Perhaps most relevantly for tonight's lecture, Justice Logan has held an appointment as a non-resident judge of the Supreme and National Courts of Papua New Guinea ever since 2011. From every possible perspective, Justice Logan is uniquely placed to speak about the origins of contemporary judicial power in Papua New Guinea. Following Justice Logan's lecture, we will have some brief commentary from Chief Justice Gibbs Salika. It is also a great privilege to introduce the Chief Justice of Papua New Guinea to you, who has generously made time to join us here in person as a commentator in relation to this lecture. Chief Justice Salika was born at Umnyao hamlet in the South Fly district of the Western Province of Papua New Guinea. He completed his primary and secondary education in his South Fly district from 1969 to 1972, and then attended the Sogeri National High School from 1973 to 1974. He attended the University of Papua New Guinea from 1975 to 1978, graduating with a Bachelor of Laws degree. The Chief Justice completed the Legal Training Institute course in 1979 and was admitted to the bar in October 1979. He commenced work as a legal officer with the Office of the Public Prosecutor. He was a state prosecutor for 6.5 years and then moved to the PNG Ombudsman Commission as its counsel in 1986. In 1988, His Honour was appointed Principal Magistrate and on 22 November 1989 appointed an acting judge of the National Court for 6 months. That appointment was made permanent in June 1990. He became the Deputy Chief Justice in 2008 and Chief Justice in 2018. Chief Justice Salika's lengthy and dedicated service to law and justice in Papua New Guinea has been recognised in Papua New Guinea's domestic and adopted imperial honours system. That recognition includes appointment as the Grand Companion of the Order of Lagou, Papua New Guinea's highest civilian honour, and appointment as a Knight Commander of the Most Excellent Order of the British Empire by Her Majesty Queen Elizabeth II. Throughout his long service to the law and to the people of Papua New Guinea, the Chief Justice has been known for his deep humility, faith, and commitment to justice. The legal profession and the judiciary in Papua New Guinea and here in Queensland, from both the state and federal courts, share a great friendship, reflective of not only our geographic connection, but also our shared commitment to the administration of justice in accordance with the rule of law. We greatly value that friendship, and in that context, it is a pleasure to be able to welcome Chief Justice Salika and Lady Salika here in Brisbane. The presence of one chief from Papua New Guinea is a great honour. Imagine the excitement we will all be feeling in 2028 when a team of chiefs from Papua New Guinea arrives to compete in the National Rugby League. But that is another story. The focus for this evening is upon the origins of contemporary judicial power in Papua New Guinea. I invite you to welcome Justice John Logan.
Well, good evening.
Good evening.
I adopt the salutation of the Chief Justice, and in particular, I'm so very pleased and honoured that my esteemed Papua New Guinea Chief Justice has agreed to be present to commentate on what follows. Well, just after 7 a.m. on the morning of 20 June 1904, the acting administrator of British New Guinea, Captain Barton, was awakened at Government House, Port Moresby. There it is in all its glory, by the continuous barking of a dog, accompanied by Mr. Manning. He investigated its cause. They saw something lying in the grass near the flagstaff. On walking closer, that something proved to be Judge Christopher Stansfeld Robinson, the Chief Judicial Officer of the colony. Robinson had a wound to his forehead and was still breathing. In his hand was a revolver. The government medical officer was urgently summoned, but Robinson died before his arrival. The consequential coronial inquiry determined that Robinson had committed suicide whilst temporarily insane. Behind that tragedy lay earlier tragedies grounded in the clash of civilisation and culture, which attended our region's experience of the colonial era in the late 19th and early 20th centuries. Detailing those background events and their sequel does not just place Judge Robinson's death in context. It remains of enduring importance in understanding the contemporary provision for the exercise of judicial power in the independent state of Papua New Guinea, that country's underlying law, and the challenges faced by its judiciary in applying that law. The 50th anniversary of Papua New Guinea's independence, which fell on 16 September last month, offers an apt occasion to promote that recollection and understanding in Australia, for which Papua New Guinea is, in every sense, Australia's closest neighbour. The necessity for the qualifying adjective contemporary in relation to judicial power in PNG in the title of this lecture must be explained. It would be an erroneous conceit to assert that the land which now comprises PNG was lawless prior to the arrival of British and European colonisers. The land was subject to a plethora of territorial rights under which particular areas were associated with and under the control of groups or clans for some purposes, but within which portions might be regarded as subject to the rights of individuals to garden and harvest. Custom and practice, which had developed over thousands of years, also ordained norms of behaviour and personal rights and related sanctions for their violation. Some of these emphasised the collective responsibility of the village or clan for the acts of the individual, with the act being punishable by the collective action of the affected village or clan. Such punishment might include the penalty of death. The killing of an individual might be warranted for any number of reasons. For example, the commission of adultery with the wife of another, perpetuating sorcery, or payback for the killing of a relative. Sorcery offered an accepted explanation for the cause of phenomena not otherwise explicable within the then limits of Indigenous knowledge. Sometimes, and unremarkably under custom, the victim would be eaten. Atonement for such killing might, for example, be made by the payment of a pig or a necklace of dog's teeth, reflecting a view that a man was worth more than a woman and that a woman was a form of property. The atonement price for the killing of a man might be higher than that for the killing of a woman. The notion of a woman as a form of property was reinforced by custom of a male suitor having to pay a bride price to the family of the proposed bride. The rugged terrain and its intersection by numerous rivers were conducive to and resulted in numerous different clan or tribal groups, which were often in conflict with their neighbours and ignorant of a wider world. Now, this account of pre-colonial custom and practice is taken from first or near first European contact descriptions, but care must be taken in treating such descriptions as of universal application. They reflect a limited encounter. Pre-colonial PNG had over 700 different language groups, with some languages spoken just within one village or by fewer than 500 people. There was neither a central authority nor a lingua franca in pre-colonial PNG. Indeed, PNG as we know it today is a construct of the colonial era and independence. The island of New Guinea was known to Europeans as early as 1511, but there was no European interest in establishing settlement on the island until the late 18th century, and then only in Western New Guinea. It was not until the last quarter of the 19th century that there was any European endeavour to establish any settlement on the eastern half of the island. Now, this slide shows an historic position. The western side, just briefly shown in yellow, is the present Indonesia and the former Dutch East Indies portion of the island of New Guinea. The southern portion of the tail, the southeast portion, became British New Guinea and later Papua. The northern part of the tail and also the larger offshore islands in green, German New Guinea. Now, how did that come about? Well, on 6 November 1884, at Port Moresby, Captain Erskine R.N., a Commodore of the Royal Navy's Australian Station, proclaimed on behalf of the British Crown a protectorate over that pink portion you saw, the southeast quadrant of New Guinea and certain adjacent islands. That was a manifestation of British interest, at least on the northern side of the Torres Strait, and that particular interest had been the source of ongoing exchanges between the British government and the Australasian colonies, especially Queensland, over the preceding decade. The proclamation of a protectorate was a step short of the establishment of a Crown colony, but nonetheless a tangible assertion of British interest. As proclaimed, that protectorate was quite literally directed to the protection of the liberties of the indigenous population and the prevention of the disposition of their lands in the identified territory, but not to its general governance, including the establishment of any comprehensive justice system. The protectorate was administered from Port Moresby by a special commissioner. For most of its existence, that special commissioner was the Honourable John Douglas, CMG. He's the ancestor of the great Queensland legal clan. Douglas did his best to ensure the proclaimed purposes were met. His judicial powers were limited to the conduct of British subjects. Limited though this response of the British government was to Australasian colonial pressure, it provoked the Imperial German government, under pressure in turn from German commercial interests, to declare a similar protectorate over the northeast quadrant of New Guinea and certain adjacent islands. This in turn, this challenge and response occurring here, heightened Australian colonial pressure for the elevation of the protectorate into a Crown colony. In 1888, the British government constituted the territory of the protectorate as a Crown colony to be known as British New Guinea, on and from the proclamation of those letters patent in that territory that occurred a little later in 1888. The letters patent recited that there was within that territory, quote, no civilised government, unquote. That recitation was true according to British values and manifested the temper of the times in the era of the 19th century European colonisers. But it imposed a foreign paternalism and will on the indigenous population. Pursuant to delegated authority under the British Settlements Act of 1887, the newly established Colonies Legislative Council established for the colony a court of record known as the, quote, Central Court, unquote, having both a civil and criminal jurisdiction to be presided over by a judicial officer termed the Chief Magistrate. The court's criminal jurisdiction embraced all offences. Its civil jurisdiction was assimilated with that of the Supreme Court of Queensland. A separate order in council anticipated the establishment of British New Guinea as a colony and conferred appellate jurisdiction on the Queensland Supreme Court in respect of the judgments of the courts of British New Guinea. The first judicial officer for British New Guinea was Francis Pratt Winter, who was appointed in 1888. Winter had practised as a barrister and solicitor in Queensland and in Fiji, including as acting Attorney General of the latter. He held that office until his resignation, which took effect on 3 January 1903. By 1903, Australia had assumed administrative responsibility for British New Guinea. Although the federation of the Australian colonies had not occurred within a 10-year window which had been anticipated in an agreement reached in London in 1887 in relation to the administration of British New Guinea, that prospect was very much in mind for those concerned with the formulation and approval of what became Section 122 of the Australian Constitution. In its final wording, that section contained these phrases in relation to the territorial lawmaking power of the Australian Parliament. quote, any territory placed by the Queen under the authority of and accepted by the Commonwealth or otherwise acquired by the Commonwealth, unquote. On 6 March 1902, with reference to section 122, His Majesty King Edward VII, on the advice of the British government and noting the passing of resolutions of acceptance by each House of the Australian Parliament, directed by Order in Council the issuing of letters patent, placing the administration of British New Guinea under the authority of the Commonwealth of Australia. The Order in Council anticipated that the Australian Parliament would pass acceptance legislation which would supersede the existing provision in respect of appeals from the courts of that colony. Until that occurred, the existing provision for appeals was preserved. Also, until the proclamation of that legislation, the Governor-General of the Commonwealth was substituted for the Governor of Queensland as the channel for communications with the British government by the Administrator of British New Guinea. In the result, the Australian Parliament did not enact the anticipated acceptance legislation until the passage of the Papua Act 1905, although that was assented to on 16 November 1905, it was not proclaimed into operation until 1 September 1906. Subject to exceptions, the Papua Act provided that the laws in force in British New Guinea at the commencement of that Act were to continue in force until other provision was made. By then, the Queensland Criminal Code, the Griffith Code, had been made applicable to the territory. The Papua Act also continued in existence as courts of the new territory, the Central Court, and other courts of the former colony. It likewise continued in existence the appointments of judicial officers constituting those courts. The right of appeal to the Supreme Court of Queensland from the Central Court ceased, replaced by a right of appeal to the High Court of Australia. The vacancy in the office of Chief Judicial Officer of British New Guinea, occasioned by Judge Winter's departure, occurred during that transitional period. It thus fell to the Australian government, not in the administration of an external territory of the Commonwealth, but in the administration of what then remained a British Crown colony, to appoint a replacement Chief Judicial Officer. Christopher Stansfeld Robinson was Judge Winter's successor. Robinson was born in Armidale in New South Wales on 16 September, now there's a coincidence, 1871. His father was the Reverend C.G. Robinson, who at the time held an appointment in the church, the Anglican Church in Walker in New South Wales. But in 1877, Reverend Robinson was appointed Rector of All Saints Church, Wickham Terrace, which will be familiar to a number here, in location at least. He moved there with his family. So it was in Brisbane that Robinson was educated, initially at Miss Cargill's school, which was a primary educational facility in the inner city, and then from 1886 to 1888 at Brisbane Grammar School. Robinson served in the office of the Crown Prosecutor for the Northern District of Queensland in Queensland's Crown Law Office for 5 years, undertaking articles of clerkship. He topped his law exams. He was admitted as a solicitor of the Supreme Court of Queensland on 5 March 1895. After admission, he practised as a solicitor initially in far north Queensland and then from 1898 in Brisbane. His application for appointment as Chief Judicial Officer was made to the Prime Minister, Sir Edmund Barton, an indication of the importance of the position. It was supported by a favourable reference from Sir Samuel Walker Griffith, then Queensland's Chief Justice, as well from the recently elected Darling Downs MP, barrister, and later Commonwealth Attorney-General, Littleton Groom. In his letter of support, Groom disclosed that Robinson was his friend. In his reference, Griffith described Robinson as, quote, an intelligent and useful lawyer whose character is beyond reproach, and opined that he was, quote, better fitted than I thought Winter was when first appointed, unquote. Robinson's appointment application was successful, and he took up office in Port Moresby on 11 May 1903. At that time, the arrangements for the administration of justice and the nature and extent of Robinson's duties, both judicial and also vice-regal in British New Guinea, were the subject of annual reporting. The 1904 report discloses that overwhelmingly Robinson's judicial duties entailed the exercise of the Central Court's criminal jurisdiction, mainly in respect of crimes of violence, but notably also including a crime of, quote, sorcery, unquote. There was minimal civil jurisdiction work. The court sat both in Port Moresby and on circuit at provincial centres. The report reveals that for the purposes of administration, including the administration of justice, British New Guinea was divided into districts, each with a resident magistrate. Those resident magistrates did not just exercise judicial power in respect of minor offences or conduct committal proceedings. They were also the government representative in their assigned district, commanded the local constabulary, and, assisted by the latter, conducted patrols in that district with the dual aims of establishing and maintaining friendly relations with the indigenous population and keeping order. To achieve these aims, the use of force, including lethal force, was by no means uncommon in the late 19th and early 20th centuries. The role of a resident magistrate in British New Guinea, or Papua as it became, was a direct precursor of the role of a district officer, or KIAP, in the post-Second World War administration of the Territory of Papua New Guinea prior to independence, although the paramilitary aspect of the discharge of duties declined as a matter of deliberate Australian policy during the last 15 years of Australian administration. Under then local law, criminal trials were conducted by judge alone. During Robinson's term of office, no tension was discerned between this provision and either the adopted Criminal Code, Chapter 62 of which, in dealing with criminal practice, provided for trial by jury in the event of a not guilty plea, or for that matter, the provision in Section 80 of the Commonwealth Constitution for the trial and indictment of offences against a law of the Commonwealth to be by jury. A little more than a decade after Robinson's death in the King and Bernasconi, following a conviction by the Central Court of a, quote, European, unquote, in respect of an offence of assault occasioning bodily harm, such a controversy did arise. It was particularly focused on whether there was inconsistency with Section 80. It came before the High Court by way of a question reserved for consideration following the conviction and sentencing of Bernasconi. The controversy was resolved in favour of the upholding of the validity of trial by judge alone and without calling on counsel for the respondent Crown. In summary, it was held that local laws made under Section 122 were not laws of the Commonwealth for the purposes of Section 80 of the Constitution. The Griffith Code, as locally amended, applies to this day in Papua New Guinea, supplying the general criminal law. Likewise, to this day, criminal trials in PNG are conducted by judge alone. Now, to visit provincial centres, Robinson used, in combination, sea transport, predominantly the government steam yacht, the Merry England. There's a photo of it, moored during a visit to Australia. Canoe and foot, assisted by local constabulary and bearers, for most of these visits, and in accordance with prevailing practice throughout the then British Empire. Robinson was also acting administrator, prevailing practice in the sense that a chief judicial officer would act as vice-regal officer in the absence of the latter. It's a practice which we still follow in Queensland, for that matter. So for most of that period, he combined both judicial and administrative actions, and these included exploration. Decentralisation remains to this day a feature of the administration of justice in Papua New Guinea, with National Court judges and magistrates outposted to provincial centres or visiting smaller locations on circuit. The description of Robinson's patrol, expeditionary and circuit duties is found in that 1904 report that includes this cryptic passage in respect of his duties in February and March 1904. The Merry England, having been rejoined off Bell Point, a course was steered for Gurabari, a distance of some 25 miles. The circumstances of the unfortunate conflict which took place with the natives of this place have been the subject of a special inquiry and need not be referred to here. In conjunction, this unfortunate conflict with the natives, quote unquote, at Gurabari and the quote special inquiry are explanatory of Robinson's later suicide. In turn, that unfortunate conflict occurred against the background of ongoing Christian missionary endeavours in the territory which became British New Guinea, throughout the Torres Straits and elsewhere in the South Pacific, on and from the last quarter of the 19th century. Those endeavours have yielded not only the sincere and widespread adherence to the Christian faith, which in my experience is not only a feature of modern PNG society, but also an interplay between that faith and custom, which is also a feature of that society. In 1904, as now, the Griffith Code reflected the values of a Judeo-Christian society. But then, and still now in PNG, that code falls for application in a society where custom, to a greater or lesser degree, depending on exposure to a wider world, continues to influence norms of behaviour. So the potential for or actuality of, quote, unfortunate conflict, unquote, is not of historic interest. Hence the importance of delving in a little more detail into the context in which the 1904 unfortunate conflict and Robinson's later suicide occurred. On and from 1 July 1871, when Christian missionaries from the London Missionary Society, the LMS, landed at Darnley Island, Erub, E-R-U-B, in the Torres Strait, with the aim of converting the indigenous population to the Christian faith, or put another way, to proclaim the light of the gospel of Jesus. There began what is known on each side of the Torres Strait and beyond in PNG as the coming of the light. The commencement of this missionary activity continues to be marked by that name each year on 1 July by celebrations in Torres Strait communities on each side of the border. The LNF's work in the Torres Strait soon extended, also in 1871, to the nearby island of Mur in the Murray Islands. This missionary work and its sequel form part of the First Encounter Background Facts in Mabo and Queensland No. 2. By 1872, LNM's missionary activities extended to what later became British New Guinea. Spearheading these activities in conjunction with LMS ministers were Rarotongan converts from the Cook Islands. One of the LMS ministers who joined these Papuan missionary endeavours in 1877 in what would prove to be his life's work was a Scot born in 1841, the Reverend James Chalmers. After ordination, he'd been appointed to the Cook Islands by the LMS, where he applied himself zealously to preaching, teaching, and wider humane activities between 1867 and 1877. Robinson's immediate successor as Chief Judicial Officer of British New Guinea, who later became a long-serving and enduringly, to this day, highly respected administrator of the Australian Territory of Papua, was Sir John Hubert Plunkett Murray, Hubert Murray. In a wide-ranging history of British New Guinea and Papua, originally published in 1912, Murray offers an account of the awful, grisly fate of Reverend Chalmers and his party in the continuance of his missionary activity at Gurabari Island. Gurabari Island, by the way, is at the mouth of a confluence of rivers on the western side of the Gulf of Papua. Suffice it to say, on Easter Monday, 1901, 8th of April, Chalmers, an accompanying minister, Reverend Tompkins, and their party, including Rarotongan converts, came on to Gorabari at a time when there was a local ceremony being conducted, the nature of which was usually confined to locals. Each of the members of the party was killed, and that particular account is drawn from the 1912 work of Hubert Murray. There's greater detail about it in my paper. Murray also states in that work, quote, "Of course the perpetrators of an outrage of this kind must be severely punished, and they were severely punished accordingly, with the loss of many lives and the destruction of much native property. There were, as usual, no casualties on the side of the government." The punishment meted out to the perpetrators was not a sequel to any conviction by the Central Court or any other court. It was a punitive expedition under the command of Lieutenant Governor LaHunt, which deployed to Gurabari Island from the Merry England on 2 May 1901. LaHunt conducted a further such expedition in 1902, albeit attended with less violence, to the end of retrieving at least the remains of Chalmers and his party. That was not successful, so there was unfinished business. The killers of Chalmers and his party had not yet been brought to justice. Further, nothing of the missionaries' remains, even their skulls, had been retrieved. At the time, access to Gurabari was via the Merry England was only possible around March each year because of prevailing tidal conditions. Hunt was absent on leave in March 1903. In turn, that meant that it fell to Robinson in March 1904 to pursue that unfinished business. This he did on the Merry England on 5 March 1904, accompanied by the resident magistrate, Mr. Jair, Mr. William Bruce, who was the commandant of the armed native constabulary, and also a contingent of local constabulary on board the Merry England. They moored off Gurabari Island. Later that day there was some trading activity with locals who'd come out by canoe towards the ship. It was thought that an Indigenous man, Inke, I-N-K-E, was the murderer of Chalmers, and that another, Emma, E-M-A, was thought to have cut off Tompkins' head. That afternoon they were seen amongst those on board those canoes. Early the following morning, many canoes approached the Merry England. They carried about 600 natives, Indigenous Papuans in all. Contrary to advice given by the more locally experienced Jair, Iaki was lured aboard the Merry England on a pretext and seized. What occurred is described in a subsequent Royal Commission report. Almost at the same time, some of the native police opened fire on the natives in their canoes lying around, from which arrows had been discharged at the ship. The firing was joined in by the acting administrator and, to a small extent, by a few of the officers and crew. The natives retreated at once, but several were killed or wounded. In a few minutes, the firing ceased. It was not long before varying accounts of the incident, some sensational, reached Australia, and Australia at that stage is administering a British Crown colony. A question was raised in the Australian Senate about the incident. A sequel to that was the commissioning of a New South Wales District Court judge, coincidentally also a Murray, Judge Charles Murray, to conduct a Royal Commission to inquire into and report upon that particular incident. Although the commission was dated 25 July 1904, it's evident from the relevant file that there was preparatory work. This included, in anticipation of the inquiry, a request of Robinson to furnish a report and also to attend before the inquiry. It was this request which precipitated his suicide shortly after he had completed his report. The Commission didn't muck around. It furnished its report on 7 September 1904. In short, Judge Murray's conclusion was that the luring of Iñaki on board the Merry England to seize him was imprudent, and that Robinson ought to have accepted the advice of the much more locally experienced Jair not to do this. It was considered that Robinson's acts were fraught with the risk of events getting out of hand. He was found to have acted in a high-handed manner and to have a too self-confident nature. His actions were distinguished from those of LaHunt in the 1901 expedition to the island on the basis that that expedition was an immediate response to the massacre of Chalmers' party and that such action was called for. They were also contrasted with LaHunt's 1902 expedition. The Royal Commissioner recommended greater maturity in future appointees to the position of Chief Judicial Officer. In the service of Australia as a successor to a self-proclaimed, uninvited colonial administration of Gurabari Island and the rest of British New Guinea, Robinson was endeavouring to enforce a value and behavioural system on an indigenous Papuan population who, if they had any understanding of it at all, were not then disposed to accept it in preference to their traditional values and behaviours. So the collision of cultures was always going to be fraught. Robinson's life to that point had marked him out as a Christian gentleman, learned in the law. There should be no doubt that he was remorseful, or that he chose to punish himself more than the law ever could. After Robinson's death, a memorial obelisk was erected by the local European population on Samurai Island to his memory. The inscription on it records of Robinson, able governor, upright judge, honest man, whose aim was, quote, to make New Guinea a good country for white men, unquote. It's evident from the Royal Commission report that this was not Australia's aim. Paternalist though it was, even in 1904, the aims of the Australian administration were always the welfare, education and, quote, civilising, unquote, of the local Papuans. Those aims were directed to making the place a good country for all men, white or not. That such an inquiry was held at all was also indicative of an intolerance of any action remotely genocidal. But the obelisk's inscription undoubtedly attests to the temper of the times amongst European settlers. Samurai Island, by the way, is right at the very end of the tail of the eastern part of the island of New Guinea. Now to Hubert Murray, Robinson's successor. Well, he certainly fitted the type that his clansman, Judge Murray, not relative, clansman, had in mind when furnishing his recommendation in the Royal Commission report. By intellect and physique, Hubert Murray possessed what these days would be termed command presence. He also had lengthy experience as a field rank officer in the reserve forces. He was then aged 42. He would find in British New Guinea and then Australian Papua challenges worthy of his talents for the balance of his life. He died in office as administrator in 1940. His judicial duties didn't differ from those of Robinson in either location or caseload. He was then the only trained lawyer in British New Guinea, so his duties also extended to the drafting of local legislation and the furnishing of advice to the local executive council. His judicial approach seems to have combined pragmatism, common sense, and understanding of the importance for Papuans of local custom, antipathy for any special treatment of the white man, quote unquote, and faithful adherence to the adopted legal system. The PNG of today has an ever-expanding legal profession, but I see echoes of Hubert Murray's approach to the exercise of original jurisdiction in the transcripts of proceedings I encounter in the exercise of appellate jurisdiction in the Supreme Court. There's limited access to the services of a lawyer for most Papua New Guineans. In turn, the assistance from legal practitioners to which the Australian judiciary and magistracy are accustomed in the exercise of civil and criminal jurisdiction, if available at all to parties at trial in Papua New Guinea, varies greatly in quality. The consequential burden in PNG on judges and magistrates in the application of substantive law and practice and procedure at trial level is correspondingly greater in PNG, and still at times requires skills of the kind possessed by Hubert Murray to do justice. Shortly after the outbreak of the First World War in 1914, the Imperial German colony of New Guinea was seized by the Australian Naval and Military Expeditionary Force. It remained under Australian administration until the commencement of the New Guinea Act, 1921. Shown in the photo before us is a contingent of the Naval and Military Expeditionary Force marching past under the gaze of tropical suit-cladded German colonials, the government house at Rabaul. You might reflect on the investment of the then German government in the building government house with that which you saw at the start of the lecture in terms of the British government's corresponding investment in British New Guinea's government house. It's eloquent. Suffice it to say, after military administration ceased in 1921, an act provided, the New Guinea Act of 1921, provided for a cessation of application of German law and a hodgepodge of laws as then applicable in Queensland to apply in the newly received mandate, League of Nations mandate territory of New Guinea. The applied laws included the Queensland Criminal Code. There was no fusion of administration, however. Papua and New Guinea were separately administered as Australian external territories until the Japanese invasion of 1942 caused the cessation of civil administration. As far as Papua is concerned, Hubert Murray gained assistance after the First World War in the provision of legal advice to the government when a Crown Law Officer was appointed in 1923 to the territory. That appointee was another Queenslander, Ralph Thomas Gore. Like Robinson, Gore had received his secondary education at Brisbane Grammar School. He'd been admitted to the Queensland Bar in 1915. He then served as associate to Sir Samuel Griffith in the High Court before resigning in 1916 to enlist in the Australian Imperial Force. He served as a gunner on the Western Front in that war. His appointment marked the beginning of a 40-year association with Papua and then later the Territory of Papua New Guinea. After returning from war service, he started practice at the Queensland Bar. He was also Honorary Secretary of the Queensland Bar Association. It was not a good time to commence practice at the Queensland Bar. There was not a great deal of work around, so the appointment to Port Moresby as Crown Law Officer was attractive to a young barrister who had married just before he went off to war service, and then by the early 1920s had a young son. Griffith must have thought well of his old associate because he passed on to him his full-bottom wig. Now, as I've mentioned, the administration of justice and judicial service of judges both in Papua and also New Guinea was interrupted by the Japanese invasion, which led to the cessation of civil government. There are many photos, too many, from which to choose in relation to the conflict on the island of New Guinea. Planning, though, for the restoration of civil government in the territory commenced well prior to the end of the Second World War and the defeat of Japan. A unit which came to be known as the Directorate of Research and Civil Affairs, DORCA, was formed in 1943. It was commanded by the polymath Colonel Alf Conlon. One of DORCA's chief roles was the provision of policy advice on the military governments of the liberated areas of Papua and New Guinea. But under Conlon's administration, DORCA ranged much more widely, anticipating the eventual independence of the territories. Conlon's biographer records accurately that work of enduring value was performed by DORCA. The territories were to be placed under one administration and their laws were to be consolidated and codified. The photo before us is of great historic interest. It's a branch of DORCA commanded by, front row, third from the left, then Major Harry Talbot Gibbs. And we all know how Sir Harry, as he became, had such a contribution to later judicial and professional life, both in this state and then nationally. But he also made a major contribution to the plans for the later post-war governance of the territories of Papua and New Guinea. In one of those great coincidences, though, if you look at the very centre of the back row, you see there then Warrant Officer Sydney Frost. In the fullness of time, Sydney Frost would become the very last Chief Justice of the Australian Territory of Papua New Guinea and the very first Chief Justice of the independent state of Papua New Guinea. So, civil government came gradually to be restored to the territories of Papua and New Guinea. DORCA's work was evident both in the 1946 transitional legislation as well as the 1949 Papua Act. The Papua Act provided for a conjoint administration as one territory of Papua and New Guinea. It also provided for the establishment of a new Supreme Court. The photo before us now shows a very tall man, that's Ralph Gore in old age, and the shortest of the judicial officers shown in that photo in tropical rig is Chief Judge Phillips, who had started his judicial life as a magistrate in New Guinea, became its chief judge just prior to World War II, and then after civil government was restored, became chief judge of the Supreme Court of the Territory of Papua and New Guinea, retiring in 1954. Now, a resident description of judicial power and the law in the post-war territory of Papua and New Guinea was offered in a 1936 article by Mr. Justice Reginald Smithers. He was appointed to the court in the territories in 1962 as a successor to Ralph Gore. Smithers remarked on the then lack of unity of ideas amongst the Indigenous population. He did, though, discern a disposition in that population to accept the authority of the Territory's courts, opining, quote, "The average Indigene in the Territory shows a strong disposition to accept the jurisdiction and judgment of a real court," his words, "providing the general justice of the proceedings is apparent." Smithers was optimistic about the future of democratic government in PNG, but guarded as to that being successful in the short term. At the end of that decade, a then recently admitted 22-year-old legal practitioner, Kerry Dillon, joined the office of the public solicitor, which had been established in 1959. In retirement, Dillon authored an account of his duties as a public defender in cases before the Supreme Court, both in Port Moresby and on circuit. The cases he describes, with their undercurrent of clashes of cultural values manifesting themselves in crimes of violence according to the code, would come as no surprise to Robinson, Gore, or Smithers. The Public Solicitor's Office, Dillon describes, had been established administratively in 1959. It represented people charged with the more serious offences and also provided advice in some civil cases, increasingly including land claim litigation. The importance of that office, the Crown Law Office, and after independence of the Public Solicitor's Office, the State Solicitors and Solicitor General's offices, and the Public Prosecutor's offices as incubators of many future members of the PNG judiciary, Sir Gibbs included, and in giving practical effect to the legal system by which PNG has been governed both before and after independence, cannot be overstated. Dillon's contemporaries in the legal profession in Papua New Guinea included many who would later serve in the judiciary either in Australia or in PNG. Warwick Andrew on the PNG courts, John Balch, District Court, Queensland, Brian Hoth, District Court, Queensland, Bill Neal, Supreme and National Courts at PNG, Clive Wall, District Court, Queensland, Peter Layla, a long-serving head of the Public Solicitor's Office, Supreme and National Courts of Papua New Guinea. During Dillon's time in PNG, Jack Lawrence Kelly, later a judge of the Queensland Supreme Court, had his first judicial appointment as a judge of the Territory Supreme Court. So too did John Patrick Shanahan, who was an acting judge in 1973. Others from this era who became prominent at the Queensland Bar, who were members of the profession in PNG, included Robin O'Regan, John Griffin, and Kevin McCreena. Whatever attraction there might be for a Queenslander in parochialism shouldn't obscure the substantial contribution which the Victorian Bar made to the PNG judiciary in the last 2 decades prior to independence. I've mentioned Sir Reginald Smithers, as he became later a federal court judge. The 3 Chief Justices of the Territory over that period, Sir Alan Mann, Sir John Minogue and Sir Sidney Frost, were each drawn from the Victorian Bar. Comprehensive internal self-government in preparation for the granting of independence came to the Territory in 1972. The Territory Supreme Court was preserved as part of that preparation. 1974 was of significance for the administration of justice in PNG. On the 27th of February that year, Her Majesty Queen Elizabeth II opened a new Law Courts building at Wagani in Port Moresby. In doing that, she made reference to the people of PNG being about to embark on the great adventure of independence. She emphasised the importance of establishing and maintaining the rule of law. Now, the terms on which the great adventure of independence were proposed to occur were the subject of a Constitutional Planning Committee report which had been established by the Territory's House of Assembly in 1972. That committee envisaged an independent judiciary. The committee envisaged a system of justice which would comprise a Superior Court of General Jurisdiction, to be called the National Court of Justice, which would be a successor to the Territory Supreme Court in its original jurisdiction, and an appeal court to be called the Supreme Court, rotationally constituted by at least 3 judges of the National Court. As a matter of deliberate policy, the Australian government did not seek to impose its will on the terms on which PNG would be granted independence. Instead, those terms were to be governed wholly by a decision of the people of Papua New Guinea through their Constituent Assembly. As far as the judiciary was concerned, the Constitutional Planning Committee's report, as submitted to the Constituent Assembly, was largely adopted. It needs to be emphasised that in contrast to many post-colonial governments, Papua New Guinea is governed pursuant to a constitution chosen directly by its people through a constituent assembly and adopted by that assembly. The constitution is truly autochthonous. Independence and the commencement of that constitution occurred on 16 September 1975. The judicial officer swearing in Sir John Geese, the first Governor-General of Papua New Guinea, is Sir Sidney Frost, Warrant Officer Frost from 30 years ago. What symmetry. The Superior Courts of Papua New Guinea, the National Court and the Supreme Court, were taken up as proposed by the Constitutional Planning Committee into the Constitution, National Court, and a rotationally constituted Supreme Court. In addition to these higher courts, district courts constituted by magistrates have been established. In turn, in addition to these, there's a system of village courts. Appointees to these must be representative of the traditional population groupings of the area in which the village court is established, and they're charged with applying any relevant custom. They deal with lower level civil and minor neighbourhood type criminal matters. There are also local land courts, and on appeal therefrom, provincial land courts which deal with controversies concerning the ownership of customary land. Like the Queensland Supreme Court, the National Court of Papua New Guinea outposts its judges and has judges travel on circuit. In that sense, there's a direct connection with the original provision for and exercise of judicial power way back in British New Guinea. In my paper, I deal with two separate periods of major tension in PNG between the executive and judicial branches. The first occurred in 1979 in what has passed into history by reference to the name of the then Attorney General, Naha Rooney, as the Rooney Affair. Suffice it to say, after a deportation order was stayed by the court, the Attorney General engaged in what proved to be an intemperate exchange of correspondence with the then Chief Justice, Sir William Prentice. Mrs. Rooney ended up being jailed for contempt, but was released in short order by an act of executive clemency. In turn, the expatriate judges pretty much entirely resigned. That left PNG without a functional judiciary about 4 years after it had become functional senior judiciary, about 4 years after it had become independent. Now's not the time or place to debate the wisdom or otherwise of all that occurred there, but a sequel to it was undoubtedly a much greater understanding and respect for separation of powers, and also the commencement of Indigenous judges in ever-increasing numbers in the higher courts of Papua New Guinea. The other period of tension occurred in 2012 as a sequel to a Supreme Court judgment which by majority had concluded, contrary to the then understanding of many in the political class, that Sir Michael Somare had not forfeited his seat in Parliament and thus forfeited office as Prime Minister. That occasioned particular angst to the at least de facto government of the Honourable Peter O'Neill, which was then in a very unstable coalition. In turn, that led to intimidation of and the arrest of the then Chief Justice, Salmo Injia, another senior judge, Nicholas Kirawong, and other pressures. I saw those firsthand, and I think Justice Collier saw the better sequel to that. By then, in October of 2012, the tensions had been diffused by an election which returned the O'Neill government, but without an unstable coalition. A little later, there was a formal apology tendered to the court by the then Attorney General in the new government, the Honourable Karenka Kua, a past Law Society president. Now, Justice Collier and I joined the Papua New Guinea judiciary as non-resident judges in 2011. On one occasion after I took up my additional appointment, it was put to me by an Australian High Commissioner that the judiciary was, quote, the glue that holds PNG together. There's a measure of truth in this observation, in that membership of the judicial branch exhibits nothing like the post-election volatility of membership of the legislative branch. It's also true in that, to my observation, now over some 14 years, there's a strong ethos of independence and adherence to the rule of law under the PNG Constitution, which permeates the judiciary. But it would be another conceit and inaccurate to conceive of the judiciary as the only binding force in Papua New Guinea. Papua New Guinea's constitutional monarchy and the pervasive Christian faith are binding influences, as is a pervasive belief in democracy and pride in independence. On occasion, one reads reports of sorcery-related violence and other clan warfare occurring in Papua New Guinea. Reading these, it would be easy to leap to a conclusion that nothing much has changed since the cultural clash which saw Reverend Chalmers and his party slain and the forces of government on board the Merry England fire upon Indigenous Papuans. In my view, the true position is that Papua New Guinea society is on a transitional journey, continuing to experience ever increasingly, as with the great spread of access to the internet, a complex interplay between customary values and beliefs and the deliberate choice of the Founding Fathers to adopt on and from independence a constitutional monarchical Westminster system of government and a legal system founded in Judeo-Christian values. That interplay isn't unknown in modern Australia. On the one hand, the affirmation, after 2 centuries of land administration to the contrary, that the common law of Australia had recognised native title, which was a position enshrined in statute, perpetuates certain customary values, yet others, notably domestic violence towards women, are regarded as antithetical to Australia's criminal justice system and general societal values. The existence of such interplay was recently highlighted by the Northern Territory's Chief Justice in a speech deprecating the advancement of customary values as an excuse for the infliction of domestic violence against women. The transitional journey in Papua New Guinea presents many challenges and seeming contradictions. Outside major urban centres, the worth of village courts and their application of custom remains very real. But it also perpetuates values which can be difficult to reconcile with a growing economy and an increasingly well-educated and growing segment of PNG's population. One facet of Australia's considerable support for law and justice in Papua New Guinea is, quote, strengthening key justice mechanisms at the subnational level, such as village courts, unquote. Yet in recent years, when I discussed this policy informally with a senior PNG law reform official, the reply I received that this was at odds with the endeavour of that commission to give PNG a modern legal system. Emphatically, the management of this and other seeming contradictions is for the people of Papua New Guinea and their government. But I've found great wisdom in an observation Sean Dorney, Keenan Dorney, Casey's brother, who knows and loves PNG, in a Lowy Institute paper he delivered called The Embarrassed Colonialist. Dorney's view is that throwing money at PNG is definitely not enough. If we're to have a relationship that is a barometer of Australia's success in foreign policy, then we need to understand PNG. We need to start learning more about PNG and treating it as an equal, not as our unfortunate illegitimate child that we're ashamed of. Papua New Guinea is a country worth having as a good, solid, friendly neighbour. Understanding PNG requires more than the 2 to 3 year postings of our diplomatic staff. There was a time, immediately post-independence, when we thought with some justification we knew Papua New Guinea. It had been administered by Australia for some 70 years, but that was half a century ago. There's a need to refresh and keep refreshing, and this is an excellent way to do it this present evening, our understanding of Papua New Guinea and vice versa. There are ways of doing that. In the judicial branch, that occurs pursuant to Memoranda of Understanding between the Queensland Supreme Court and the Papua New Guinea, the Federal Court and the Papua New Guinea Judiciary. A deployment of the Queensland Bar, funded by AusAid to conduct a workshop at the Legal Training Institute, is another very successful, mutual way of engendering that understanding. Half a century after independence, much had changed in the judicial branch in PNG. The National Court has busy commercial and judicial review tracks, as they're called. These reflect increasing economic development and sophistication in governance. It has a well-managed judicial education facility, the Centre for Judicial Excellence, which delivers high-quality programs, not just for local judges and magistrates and judicial support staff, but increasingly for judiciaries and magistracies in other South Pacific countries. We need to recognise that it's a legitimate aspiration of PNG to have that leadership role in relation to judicial education in Papua New Guinea. Yet another marked change is the magnificent recently completed National Courts Complex at Waigani, which sits so very appropriately immediately next to the Parliament building. It was erected wholly from public funds from the Papua New Guinea Consolidated Revenue. The commitment entailed in that cannot be overstated as far as the importance of justice placed by the people of Papua New Guinea through their parliament. Well, to finish, at last you might think, with an expanding population, Papua New Guinea faces great challenges in finding the financial and human resources to govern itself according to the constitution its founding fathers adopted. But to my observation, the will to do so is strong. There are not many countries which, half a century after independence from a colonial type regime, can claim still to be governed by the constitution then adopted and as later amended according to law. This should be a source of justifiable pride in relation to the stage of Papua New Guinea's journey on what Her late Majesty termed the great adventure of independence.
I now invite Chief Justice Sir Gibbs Salika to provide some commentary in relation to that wonderful lecture.
Yes. Thank you, Chief Justice. Thank you, Justice Logan, for that very informative lecture. All I need to say is this, that yes, we've had our issues from the time of our colonizers. The British came, yes. They came, and the governor at the time was Sir William McGregor. Sir William McGregor established a station at the mouth of Pahaturi River at Mobodoan, directly opposite Saibai Island. And that was the first station in the Western Division that Justice Logan talked about. That probably the Papua was split into divisions. And my division was the Western Division of Papua, right at the western end, bordering the West Papua or West Irian, Indonesia, and coming to the Torres Straits, and that's where I'm from. I'm from the PNG side of the Torres Straits. That's I share my land boundary with the Australian international border in that part of Papua New Guinea. So that's where I'm from. My hometown is Daru, and the province is Western Province, and my place is at the Pahaturi River, and that's where Sir William McGregor decided to establish the station, and he established the station there, and that's where Beaver and others used to live when they were on patrols in that part of the country in the 1890s. In the 1890s, we were there already. We were there before the British came, or the Australians came for that matter. We were there before. And so we saw all that happen. My ancestors told the story about Robinson. Justice Logan sent me his paper earlier this morning. I read it and I said, I know this story. I know Robinson's story. And the story of Robinson is, he told it differently. I'll tell it my way, the way we Papua New Guineans have told it. The story is this. Reverend James Chalmers was on his missionary journey going towards the west of Papua New Guinea, to my side of the country. And he met his death on the Guarabari Islands of Kikori. There's a river system there, and the Kikori River system. The islands of Guarabari are on that basin there. And for some reason, whatever it was, I don't know why James Chalmers decided to go there, but that was how he met, where he met his death. And after that incident happened, the people went back to Port Moresby, and Robinson was the acting administrator or governor at that time, and so he decided that he would go and avenge the death of James Chalmers. James Chalmers was a well-known person who frequented that area of Papua, and our people called him Tamate because our people could not pronounce his name properly, and so they called him Tamate. Today there is a United Church on my island, Daru Island, which is called the Tamate Memorial Church. It's been built when it is built and then rebuilt a few times already. So, but it is still named the Tamate Memorial Church of Daru. And but after the delegation went back to Port Moresby, came back to Port Moresby, the story was told to Robinson. Robinson then put up a group of people to go and avenge the death of James Chalmers. And so he went. He went and massacred the Guarabaris on Guarabari Island. And then after he did that, he returned to Port Moresby. London heard of what he had done, and they summoned him. Thus, that led to his suicide at Konidobu in Port Moresby. That's the local story that I know. So when I read Justice Logan's paper, I said, yes, I know the story. And so thus is our PNG version, the Papua version of that story of the massacre at the Guarabari Island. The London Missionary Society was the people. They were the people who were driving the message, the message of the light arriving in Papua. Reverend Samuel McFarlane arrived in my part of the Western District in 1874. And as Justice Logan said, a missionary college was set up on Danley Island, and a lot of our people went to Danley Island to get educated in church work, and then later on released to come back to our part of the mainland Papua to evangelize our people. And that was what happened. And eventually the mission that was set up on Danley Island moved closer to Saibai Island, where a lot of our people went to do evangelistic training, and then went on to evangelize the rest of our part of the world in the Western District. And so that's what happened that's the story my ancestors told me. My grandfathers and fathers, they told me this story. That story is in my head. And so when he told me, I said, well, I don't need to write anything because that story is in my head. Passed on from generations to generation. And so when London heard of what Robinson had done, they summoned him. That is the story that I know. London summoned him to go back to London to answer for his whatever he did, because he was the one who ordered the massacre of the Guarabari people. London summoned him, and so before he could go, he decided to end his life the way he did. And at the beginning of his talk, he said there was somebody, dogs were barking, and they were, yeah. And so that was Robinson, who had killed himself with a revolver and lying dead there. He was alive when found, but he died soon thereafter. So that's the story of that Robinson. But yes, I can agree with Justice Logan that over the years from independence up to today, the people of Papua New Guinea have great respect, have the greatest respect for our courts, for the courts. Our people trust the courts and have faith and belief in our courts. They will not believe and trust our politicians and any other people except the courts. Our former Solicitor General is among the crowd here, and I see him here, and I'm saying he can testify on his own. You can ask him, who do the people support in PNG? They will tell you they don't support politicians. They trust the judiciary, and I can say that yes, our people trust the judiciary. The Australians, I see Mal Veritimos here, and the others who have practiced in Papua New Guinea, they will know that what our people trust most is the judiciary, and it is still the same today. It is still the same today. Our people always trust the judiciary. Politicians will make decisions. They take those matters to court, and the judges make decisions, and our people believe and have faith in the decisions of the court. And with Justice Collier and Justice Logan there that assist, and then in the last 2 years we've engaged a few other more Australian judges to serve on our bench, and they are now serving right throughout the country as well. And the power that the courts have is enormous. It's enormous power, according to our people. They see the courts. The courts can order death out of nothing. And when people see that, oh, why is he killed? Oh, the courts ordered him. Well, then they will say, all right. So it's the big power that our people truly respect. And they say, well, the courts, they live by the law and they eat by the law, and they will do what is lawful, and they make the orders accordingly. And so our people are with us in relation to governance in Papua New Guinea. But I want to thank John for Justice Logan for a bit of history before independence. The judges who were serving, that there were 7 judges that used. Those were our first Australian judges after independence. Straight after independence, those were our 7 judges. And over time, today we have 47 judges serving on the Supreme Court and the National Court of Justice. Just recently, last year, an amendment was made to the Constitution, creating the Court of Appeal in between as well. And so starting next year, we will fully, properly establish, we're currently working towards that. We will fully establish the Court of Appeal next year, where it will be fully operational. So it will have a National Court, Court of Appeal, and the Supreme Court will be the Constitutional Court, as it is. So, yeah, the power that it belongs to, the judicial power under our Constitution belongs to the people of Papua New Guinea. All power under our Constitution belong to the people of Papua New Guinea. To the judges and the magistrates, the people have given us that power, judicial power, through the Constitution to us to perform our role as judges. So it's the Constitution, again, of Papua New Guinea that gives that power, that mandate for the courts to exercise. It's the people's power, and of course, because of that huge power that the courts have in Papua New Guinea, we are mindful of the fact that, yes, that power sometimes can corrupt people, but we have always said that, no, we must use that power with full responsibility. And our people are aware of that. And they also they support and trust and believe in the judicial system of PNG. And so, as I said, what you've heard from Justice Logan, that's from the historical perspective right up to the modern stage. I'm sure he will pass his paper around for everybody to read, but I've read it earlier this morning only, and then, but yes, it's good reading material. Thank you very much.
Well, I'm sure you'll all agree we've been the beneficiaries of an extraordinary amount of research and careful thought and expression by Justice Logan in that incredible tale of resilience, respect, recognition of nationhood and national pride, leading to independence, demonstration of the enormous strength required to defend the rule of law, and now reflecting those historical connections between Australia and Papua New Guinea. We share a very close and respectful mutual relationship of support and collegiality. Such a demonstration of collegiality can't be improved on other than by the Chief Justice of Papua New Guinea joining us for this lecture tonight. So would you please join me once again in thanking Justice Logan for his lecture this evening and the Chief Justice for his commentary. You're all invited to view the legal heritage display in the Portrait Gallery if you haven't had an opportunity to do that yet. It's been curated by the Supreme Court Library in collaboration with Justice Logan and the Federal Court, and there are also refreshments to be served. Thank you.